Thank you so much for the opportunity to testify. I'm here to address the threading permit, and my name is Renee Flaherty, and I'm an attorney at the Institute for Justice, a nonprofit public interest law firm, and I represent Ms. Jagtiani and the other plaintiffs in the Chudasama versus Louisiana State Board of Cosmetology case. And you'll hear from Lata as well, and you'll hear from my colleague Lee McGrath, also at the Institute for Justice, about the braiding permit. So I'm here today to talk about three problems with the proposed rule. First, the 10th grade education requirement. Second, the definition of threading. And third, the annual sanitation requirement. If these problems aren't addressed, threaders will have no realistic means of complying with the rule. And as a result, the rule will accomplish nothing, and our lawsuit will have to move forward. First, the threading permit requires the equivalent of a 10th grade education. We've asked the board's lawyers, and it appears that the board has no objective standard for determining what equivalency means and no plan for coming up with one.
That's not correct.
Okay, well, like we said, we're not going to debate it. Please proceed, Ms. Flaherty.
Okay, we'd love to find out if that's not true, certainly.
Yeah, and if you want to address it when she's done, go ahead.
Okay, great. And the reason this issue is a problem is one of our clients, Ushaben Chudasama, she graduated from high school in India. And so most threaders, including our clients, are immigrants from South Asia or the Middle East. And some of their home countries don't educate women in the same way that we educate women here. And so many threaders that come to the United States have little or no formal education. This doesn't mean that they can't safely thread or that they don't have a right to make a living just like everyone else. The proposed rule will discriminate against these women who've come to the U.S. seeking a better life. So the 10th grade education requirement should be removed. Second, the definition of threading in the rule is, quote, the practice of using a thread to remove facial hair. But threaders also remove hair from a customer's ears, arms, or neck. The word facial should be removed from the definition of threading. It makes no sense to allow threaders with a specialty permit to remove hair from the face with no cosmetology training while requiring 750 hours of cosmetology training for someone who removes hair from the neck. And third, the annual sanitation training has to go. Everything a threader needs to know about sanitation can be taught in a one-time, one-hour course. My firm recently won a threading case in Texas, the Patel versus Texas Department of Licensing and Regulation case, in which the state's 750-hour threading license was struck down as unconstitutional by the Texas Supreme Court. And in that case, a medical doctor and expert witness testified for the threaders. The doctor, Seema Patel, taught a one-time, one-hour sanitation course for threaders at her spa in Pennsylvania, where threading doesn't require any kind of license. In this course, threaders learn three simple responsibilities: wash your hands, use new thread, and keep your work area clean. The rule also says nothing about what this training will involve or how long it will take. Dr. Patel's one-time, one-hour course covered all of the following: how to sterilize the work area at the beginning and end of the day, proper use of antibacterial products and disposable products, using a fresh thread for each client, washing hands before and after each client, wearing a mask if they have a cough, common skin concerns, when the threader should not be performing a service due to medical problems or recent medical treatments, and reporting adverse incidents. And her course was effective. In a 28-month study, there were over 20,400 incidents of threading at the spa, and only one adverse reaction, a small cut on a person's face, cheek, that quickly healed. It's therefore irrational and unnecessary to make threaders undergo the same sanitation training year after year for the entirety of their careers. We don't make lawyers retake the bar exam or architects and engineers retake their licensing exams. You should not make threaders go back to school year after year to learn something every adult knows how to do. Wash your hands and keep your work area clean. Yet the proposed rule requires annual training and doesn't say what that training will be or how long it must be. The solution is a one-time, one-hour training along the lines of what Dr. Patel required at her spa. We've provided your lawyer with a copy of her report and supporting material. Finally, the threading businesses, not cosmetology schools, should be the ones to conduct the sanitation training. If the board requires threaders to attend cosmetology schools, just for the sanitation training, the schools may not even offer the course because it isn't going to be profitable for them to do so. Or the schools may attempt to bundle the sanitation training with training that threaders don't need. These problems will only be exacerbated if you require the course to be repeated year after year. A specialty permit that no one can actually comply with does nothing to help threaders and does nothing to make the public safer. The solution is this: require threading businesses to cover a one-time sanitation curriculum set by the board. All threaders would have to undergo the curriculum before they could start work, and the board should require certification of completion to be kept on site with the threader's permit, so that inspectors can confirm that it has been completed. And I'll be happy to answer any questions.
Ms. Morris, did you want to say something about the,
10th grade education, and the only reason that I think that needs to be addressed, really not in the context of this rule, but that is the minimum education standard for all licenses issued by this board. There is a pending Attorney General's opinion request that was requested by a state representative, which questions the process that the board has been using. And that question was posed to me in discovery, and we have not yet responded because we were trying to get the Attorney General opinion to make sure that we gave appropriate information. But there is a process that is used by the board, has been used by the board many, many years, but that process has been questioned, so we're re-examining it. But there will be an objective standard for 10th grade.
any questions?